Hello, everyone. My name is Beata Leah. I'm an immigration attorney at Minsky McCormick and Halligan in Chicago, and we provide immigration services to immigrants coming to the United States from all over the world, including family-based immigration, employment-based immigration, removal, asylum, um, and everything related to U.S. immigration. So I'm here today because I wanted to address a question that many people will have today, and that is, what are my options if my H-1B was not selected in the lottery? So today, individuals who had registered for the annual H-1B cap have been notified as to whether or not they were selected in this year's lottery, or at least in the first round of this year's lottery. So they and their employers have been notified. And as in most years past, many were selected, but most were not selected. And that leaves a very large pool of people who have this question at this time every year as to what are their options to remain in the United States, or if they're not in the United States, to come and work in the United States in the near future, until such a time when they are selected in the lottery, perhaps next year or the following year. So again, this group is anxious to explore other options, and so I will address some alternatives to the H-1B. But before we get into the alternatives, I first want to say that there exists still the possibility that USCIS may hold a second or subsequent lottery. So there are, as most of you know, 65,000 regular H-1B visas plus an additional 20,000 H-1B visas reserved for individuals who have at least a U.S. master's degree or higher. Now, USCIS takes more than sufficient or selects more than a sufficient number of H-1B registrations to meet that demand, but there are many reasons why the demand may not be met in this first round. For example, a percentage of those H-1B applications will be denied because they are not eligible for a variety of reasons. Either the degree is wrong, or the person's experience doesn't relate to the position, or the employer cannot satisfy the prevailing wage, or there's a whole list of reasons why an H-1B may be denied. But so typically a certain percentage of H-1Bs will always be denied. And obviously USCIS cannot predict how many will be denied. Further, as a result of the pandemic, but just for a variety of reasons, an employer could simply change their mind and decide not to file an H-1B, even though they had registered an individual for the cap. In the coming 3 months, the window of time when they have to submit the application, they may change their mind for a variety of reasons and simply not file for that individual. Or they may file and withdraw because the individual changes their mind, or for a variety of reasons, again, they may withdraw the job offer. So last year, for example, the USCIS did hold a second lottery in August and distributed thousands of additional visas that were not selected in the first round in March. And so again, we don't know if there will be a second round, but it is absolutely possible, just as it occurred last year, that there could be a second round, a second lottery later this summer before September 30th, because that's the date by which they have to distribute all of those visas, to release, again, additional H-1B visas. So for those who are not selected today, all hope is not lost. It is still possible that there would be a second lottery or even a subsequent lottery during which you may be selected. But now, again, let's assume that the majority of the people for whom an H-1B registration was submitted will not be selected, just as is the case in all previous years. What options do they have to keep working in the United States or to come to the United States to work for this employer? Well, there are a variety of options. There often isn't a solution in these cases, but sometimes there is. So the first thing we want to look at is the individual eligible for another type of work authorized visa? For example, citizens of Canada and Mexico may be eligible for a TN visa. Citizens of Singapore and Chile may be eligible for an H-1B1 visa. Citizens of Australia may be eligible for an E3 visa. Further, individuals who have previously worked for this sponsoring employer at their affiliate or subsidiary outside of the United States for a period of a year may be eligible for an L1A or L1B visa to be transferred to the United States. And individuals who are extraordinary in their field, they're at the top of their profession, whatever that may be eligible for an extraordinary ability O1 visa. So it's worth exploring whether or not there are other visas that may be that may make that individual eligible to work in the United States. Now, another thing to look at is the individual married, and is their spouse in the United States on the type of work authorized visa that would enable the dependent spouse to have work authorization. So some dependent spouses can get work authorization, such as the dependent spouses of L1, E2, J1, E1, and H-1B visas in some cases. So the H-4 dependent of an H-1B worker who has an I-140 approval can also obtain work authorization. The next thing to look at is assuming the individual is on an F1 visa, can they extend their studies to obtain more CPT, curricular practical training, or OPT work authorization? Or if they are an F1 student and they have a STEM degree, can they obtain a STEM extension? So individuals who have STEM degrees in the United States can obtain up to 36 months of work authorization on a STEM OPT if they're working for an E-Verify employer. Another thing to look at is whether or not the individual would maybe qualify for a green card under a variety of categories. This is likely not the case, but again, it's worth looking into. If the individual has a family member that may be able to immediately sponsor them, such as a U.S. citizen spouse, or in some cases a permanent resident spouse, or a U.S. citizen child who's 21. Has the individual been selected in the diversity lottery? Again, the odds are that they have not, but it's worth exploring. Are they eligible to sponsor themselves for a green card, such as EB1 green cards for extraordinary workers, or a national interest waiver for individuals doing something that is in the nation's interest? So again, there are many other ways of obtaining a green card in the United States, but it's worth exploring and finding out whether there would be a mechanism for them to file for a green card and obtain work authorization through that application. There are also humanitarian-based options, again, likely not applicable to many individuals who are applying for the H-1B lottery, but in some cases it may apply, such as temporary protected status. So temporary protected status is a form of humanitarian relief eligible for individuals who are in the United States who had come from countries where there is a civil war or a natural disaster, and that they're currently not able to return. So for example, individuals who are from Syria, Sudan, El Salvador, and other countries may be eligible for TPS, which has work authorization. There's also the possibility, again, the minuscule possibility that an individual may in fact be eligible for asylum, VAWA, a T visa, which would enable them to work in the United States. So again, this is not a list that explores every possible option, but there are, in some limited cases, individuals who may have another form of relief and another way of working in the United States. Now, some people may also ask whether or not President Biden's immigration reform bill will be able to help them. And at the time of this recording, that is not yet known. Now, it is true that the reform bill, the U.S. Citizenship Act of 2021, that President Biden introduced in February, does include various provisions that will help employment-based immigrants and temporary non-immigrants. For example, by extending the ability to obtain an EAD or work authorization to all H-4 spouses, including those that, where the spouse does not yet have an I-140 approval. But as of right now, that has not yet passed. We don't know if it will pass, when it will pass, and even if it passes, what it will look like, because naturally through the legislative process, there are revisions in both the House and in the Senate. They can add things, take things away, amend it, and so we don't know at the moment whether or not something like that would help. But again, there are discussions on the table currently occurring in the Congress to provide some relief to employment-based non-immigrants that may in fact help later on down the road this year or possibly next year. And finally, some employers consider sending their employees offshore. And that may include sending them back home to their own country where they can continue working remotely, just like we have been working remotely here during the pandemic, but working remotely from their home country. Some employers already have a presence outside of the United States, an affiliate or a subsidiary in another country, and they look to whether or not it would be possible to send this employee to work at that affiliate or subsidiary, even if the employee is not a citizen of that country where they happen to have a presence. They can discuss the possibility of sending that individual to work there temporarily. And that, interestingly, could open the door for that individual to later come to the United States on an L1A or L1B visa, because when the individual has worked for an entity abroad for at least a year, they can then later come back to the United States on an L1A or L1B visa as an intra-company transferee. Similarly, some companies are in fact exploring offshoring their employees in Canada. And in fact, there is a company called Mob Squad, which works with the Canadian government to help US-based companies start subsidiaries in Canada and to provide both temporary work authorization and permanent residency in Canada for their employees. And what's interesting is that if those employees stay in Canada long enough, they may be eligible to obtain Canadian citizenship, which then makes them eligible to come back to the United States on a TN visa. Now, obviously, the idea of offshoring an individual, whether it be as an employee directly, as a contractor, in any of these countries has very complex ramifications in terms of tax, employment law, corporate law. But again, depending on the size of the employer and the importance of this particular individual who was not selected, it is worth exploring those options. So again, for those of you who were not selected this round, don't give up hope. There may still be another lottery this year. But if you were not selected in any of the lotteries this year, do explore a variety of both employment-based, family-based options, and feel free to schedule a consultation with us to determine if there is another way for you to remain in the United States or if it makes sense for you to go elsewhere so that you can later return at a time when you are selected or perhaps on a different visa type. Thank you so much for listening. I hope this was helpful. And again, my name is Beata Leah. I'm an immigration attorney in Chicago. If you'd like to speak with me, you can call the office at 312-427-6163 or go to our website at www.mmhpc.com. Thank you and take care.